Mrs. L.
If we could start with the Keegan Mowbray case.
Yes.
And I apologize if I said that improperly. Maybe.
Mowbray?
I just heard it say.
All right, so we're on the record in docket 25-00786. That is people of the state of Michigan versus Keegan Mowbray. Will the parties please introduce themselves for the record? Mrs. South.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
So Mr. Ogletree?
Yes. Aaron Ogletree on behalf of Mr. Mowbray, PA number 69167.
All right, and sir, you are Keegan Mowbray, is that correct? All right, thank you. This is the time set for a final pretrial on the matter. Ms. Zell, how are we proceeding?
Your Honor, at this time, it's my understanding a plea will be done in this case. There is a slight plea agreement here. At this time, the offer that's been extended is for Mr. Mowbray to plea as charged to the domestic violence count under MCL 750.812. Upon that plea, we would also be agreeing to HIDA status.
Is it a Killebrew to HIDA?
Yes, Your Honor. And that would also be a no contest plea, Your Honor.
All right, what am I taking as the factual basis for the no contact plea? All right, and you agree to that, Mrs. Zell?
I do, Your Honor.
All right.
Yeah, it was sent by the prosecution.
All right.
And it was shown to us previously.
All right, so let me restate the agreement for the record and to see if I got it right, Mr. Ogletree. This is a plea to count one, the domestic violence. It's a 93-day misdemeanor, NRR $500. There is an agreement to a Killebrew of HYTA status, and this will be a no contest plea.
Yes, to hide a no contest, yes.
And what is the no contest plea? What is the reason for the no contest plea?
To allow the
All right, may I inquire of Mr. Mowbray of his advice of rights concerning no contest plea?
yes.
All right. So Mr. Mowbray, you understand you're pleading as charged to the 93-day misdemeanor under $500. There's a Killebrew agreement between your attorney and the people of the state of Michigan that you receive HYTA status. If I was not going to give you that at sentencing, you'd have the opportunity to withdraw your plea. Do you understand that, sir?
Yes, sir.
All right. You have the following trial rights in this no contest plea, and I'll walk you through those rights. You have the right to be tried by a jury, to be presumed innocent until proven guilty. To have the prosecutor prove beyond a reasonable doubt that you are guilty. To have witnesses against you appear at trial. To question any witnesses that are brought against you. You are represented today by attorney Mr. Ogletree, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. You understand that, sir? You have the right to have the court order any witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your no contest plea is accepted, you'll give it the claim that no contest plea was a result of any promises other than what's been stated on the record, or threats that it was not your choice to plead no contest to this matter. You'd also be giving up the right to appeal anything from trial, since you'll be pleading no contest instead. Is it still your wish today to waive your jury trial rights and plead no contest?
Sure.
All right. For the factual basis, I am taking the police report from LPD for this is case number 255-190-1664. Is that a fair statement, Mr. Zell?
It is, Your Honor.
Mr. Ogletree?
Yes.
Okay. So all this occurred on or about February 20th at 900 Long Boulevard, apartment 800 in the city of Lansing. And the victim, Carmen Marie Hargrove, had been with the defendant dating off and on for 2 years. They have no kids in common. There was an argument, and it appears that Mr. Mowbray nudged or pushed, is how it's written in here, pushed Miss Hargrove towards the bed, which would be an offensive touching of another, and there's nothing to indicate that it was done in self-defense. There's some other activity afterwards, which would lead to the offensive touching of the other, not in self-defense and done intentionally. Anything else for the no contest plea factual basis, Mrs. L?
No, Your Honor.
All right. Anything, I could take any one of this offensive touching. There's also an allegation that they grabbed the bun of her hair at some point, but the initial one was grabbed her right shoulder and nudged and pushed her towards the bed. Mr. Ogletree, anything towards the factual basis?
No, Your Honor.
All right. I find for the no contest plea that the factual basis is affirmed. And I'm going to refer to probation. So, Mr. Mowbray, this probation is one floor down all the way to your right. If you go down, they'll either set up an appointment to see you or they'll see you then. I'm not sure what their schedule is. But they're going to ask you some questions about the case. We will set, what ends up happening is they'll set for sentencing and we'll see what options are available to us in sentencing. This is a little tricky. It gets a little tricky here because it is no contest plea, but they want you to take responsibility for your actions. Okay. And so, and that's what they'll report to me. We'll set sentencing for
July 15th at 1:30.
July. Does that work with your schedule, Mr. Ogletree?
Yes.
Okay, July 15th at 1:30.
I'm gonna ask, would it be in person or by Zoom?
You can be via Zoom, sir. Mr. Mowbray should be here in person. Because I don't know what the recommendation is. Okay. So if there's a recommendation that's other than HYTA, that's part of the Killebrew, Mr. Mowbray would of course have the ability to withdraw his plea, and you may want to be in person when he does that. Mr. Mowbray would definitely be in person when he did that. Okay. All right. So
That's one more thing. Well, I received an email copy of the pre-sentence report.
the pre-sentence report will be sent to you by email. Yeah.
Usually the day before.
Yeah, they usually get it the day before, and that'll be a part of the sentencing is to make sure that you have had time with your attorney to go through the pre-sentence report. All right. Yeah, usually get it the day before, and then go through it with their client probably day of, and that probably your preference would be to be in person. All right. All right. Anything else for the record in 25-00786, Mrs. Zell?
Not for the people.
Mr. Ogletree.
No, Your Honor.
And I'll give back the factual basis to Mr. Ogletree or whoever is responsible, so it's not in the court file. All right, Mr. Mowbray, we'll see you on July 15th. Good luck to you, sir.
Your Honor. Mr. Mowbray, you have the seat here. I'm looking at information.
Sit next, Mrs. Zell.
If we could call the Deasia Todd case, I believe her and her attorney are present via Zoom.
That is correct, Your Honor.
All right, so we're on the record in docket 24-03620. That is People of the State of Michigan versus Deasia Todd. Will the parties please introduce themselves for the record? Mrs. Zell.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the People.
Mr. Samuels.
And Matthew Samuels on behalf of Ms. Todd. We are both present via Zoom with permission of this court.
All right, thank you. And ma'am, you are Deasia Todd, is that correct?
Yes, I am.
And you can hear me all right, Ms. Todd?
Yes, I can.
Okay, thank you. This is the time set. I have it set for a contempt hearing. I also have a nollie process on the case. So Mrs. Zell, how we proceed?
Your Honor, at this time, it's my understanding that Ms. Todd has entered a plea in her felony case. Part of that plea was a global resolution with this case, that being the dismissal of this case. We believe that the contempt hearing should be dismissed along with this underlying case.
Your Honor, and I do agree with what was just stated on the record. However, I did want to address the contempt charge because it's probably something that shouldn't happen in the future. I believe this contempt charge was for out-of-state travel. Ms. Todd got permission from Judge Cole through pretrial services to go on the out-of-state travel. And I have submitted that to your court. So I don't know what the mix-up was.
Well, I think that there's different goals pursuant to different judges' orders. So I think she was okay to travel on the family court case for no contact, but out of state travel, but she was arraigned by one of our judges in 54A, and she's got to get permission by the arraigning judge.
This wasn't a family court case. This was a criminal case related to this matter, and she was arraigned by this court as well.
Was it a separate charge?
It was a separate file, and that's why it was the file that was based on this dismissal. Yeah,
I think that's the problem. I think she needs permission from because it's a pretrial condition until this is taken care of. She got it on another file permission, and she didn't get it on this one.
What happened was she contacted pretrial services. Pretrial services only contacted Judge Cole in the circuit court, and not this court.
And the only person who would know that Ms. Todd has multiple files are probably Ms. Todd and you.
Okay.
Yeah, that's where the mix-up. You're absolutely right. This shouldn't happen. I'm assuming that she got permission for out-of-state travel, that it should cover all the files. I don't see why it wouldn't. But I think that's the mix-up.
Yes, absolutely. And I don't think it clicked for any of us that this case was still pending.
Absolutely.
And that we needed permission in this case.
Right.
And again, I know it's been dismissed. I just felt necessary to address that.
No, I agree. And that may come up with pretrial services that they have to, if there is a question, they should contact all the judges who have arraigned it. I think that's where the problem lies. But all right, so we'll dismiss without prejudice the file per negotiations, and then I will dismiss the pretrial condition violation. Pretrial out-of-state travel violation. Based on the negotiations that have already taken place, I have a nollie process in my possession concerning this is dismissed pursuant to the global resolution. So Ms. Todd, I would take about the afternoon, because all this has to be purged from the system, and it's all a computer. So I would take to make sure that all these are purged from the system. 4 hours, no out-of-state travel, the no contact order, no possession of firearms. That'll all be until I'd say 4 or 5 pursuant to the computer. All right, ma'am? Just so you know.
Okay.
All right. Anything else? I've signed the nollie process for dismissal of the case and the out-of-state travel order that led to the violation of the pretrial condition. So both of those are dismissed without prejudice, which means it's a default, ma'am. The people could reissue if they choose to, but realistically, the cases are dismissed, all right?
Mm-hmm.
Is that a yes?
Yes.
All right, thank you. Anything else for the record in 2403620, Mrs. L?
Not for the people.
Anything else, Mr. Samuels?
Nothing further. Thank you very much.
All right, Mr. Thank you. Good luck to you, ma'am. You're all set.
Thank you.
Okay, we break out number Dean Mihawk and Demetrius Harris. Jalissa Spearman is Mr. Harris's client, and he's going to want to talk to him a little bit, but Ming Dihong, Ding Mihawk, and Demetrius Harris. I can go right now.
So I'm ready, Your Honor, on Janisha Davis, Nicole Fitzgerald, and then Kyla Rogers from the 10 a.m. docket.
Yeah, I did. It's Demetrius H. on here.
Yes, I am.
All right. All right. All right, Mr. Harris, what case did you say you're ready on?
Janisha Davis, Nicole Fitzgerald, and Kyla
This
Rogers.
is on Janisha Davis.
Excuse me, sir.
Mr. Alvarez?
Yes, I was struggling to come in the Zoom meeting.
All right, well, the only alternative we have is to have it live, so I can reset it.
Your Honor,
Yes.
if I may, Mr. Alvarez is my client. I am ready to proceed on that.
All right, you want to go ahead? So let's go on Davis, and we'll go on to Mr. Alvarez next.
Thank you, Your Honor.
All
Thank
right.
you, sir.
So Miss Davis, we'll call your case of 2401676. That is people of the state of Michigan versus Janisha Davis. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Ms. Davis. She is appearing via Zoom, Your Honor.
All right, and ma'am, you are Janisha Davis, is that correct?
Yes.
And you can hear me all right, Miss Davis?
Yes, I can.
All right, thank you. This is the time set for pretrial in the matter. Mrs. L, how are we proceeding?
Your Honor, it's my understanding that at this time, we're going to ask for this to be set for a final pretrial.
And is that a fair statement, Mr. Harris?
That is correct, Your Honor. I've spoken with my client regarding the case and the offer. My client is considering that offer. We would be requesting the court set this case for a final pretrial while my client considers that offer, Your Honor.
All right, we'll set for final pretrial, huh?
June 3rd at 8:30.
June 3rd at 8:30. All right, we'll set for final pretrial on June 3rd at 8:30. Ms. Davis, you'll get notification of that final pretrial. That will be sent to your last known address with the courtroom, which I believe is the Kalamazoo Street address. Is that still a good address for notification purposes?
Yes, it is.
All right. Anything else for the record in 2401676, Mrs. L?
Not for the people.
Mr. Harris.
Not from the fence, Your Honor.
All right, we've set a final pretrial on June 30 at 8:30. That'll be live in person on the 6th floor of City Hall. Ms. Davis, thank you for your appearance today.
Thank you.
All right, and then the next one we'll call Mr. Alvarez.
Yes, Your Honor.
All right, Mr. Alvarez, you can unmute. So, Mr. Alvarez, you can unmute your device. Part of the technological issues. And Mr. Alvarez is gone.
So if we would like to handle Ms. Fitzgerald while we wait for
All right.
Mr. Alvarez to return, Your Honor.
I think he's just rejoined us.
Oh.
Maybe. Let's see.
Hello, sir.
All right, there you go. All right. All right, Mr. Alvarez, we're ready to call your case. We're on the record in 2501052. That is people of the state of Michigan versus Jesse Alvarez. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the People.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Alvarez, who is appearing via Zoom, Your Honor.
And sir, you are Jesse Alvarez, is that correct?
Yes, sir.
All right, you can hear me all right, Mr. Alvarez?
Yes, sir.
All right, this is the time set for a pretrial on this matter. Mrs. L, how are we proceeding?
Your Honor, at this time, we're going to be asking for a second pretrial. We believe that this matter could be resolved. However, defense has asked for a little bit more time for compliance purposes.
And is that a fair statement, Mr. Harris?
Yes, Your Honor. My client is working to get the dog, in this case, licensed or otherwise resolve this issue. He's asked for a bit of time to get that done. So we would be requesting this get reset for a new date.
All right, I think we're,
I'll go on for
yeah, 4 weeks.
June 17th at 9.
June, so we'll reset the pretrial for June 17th at 9 o'clock. Mr. Alvarez, you'll get notice sent to your last known address with the court, and we have, is it that Narragansett address? Is that still a good address for you?
Yes, sir.
All right, we'll reset for June 17th at 9 o'clock. Anything else for the record on 2501052, Mrs. L?
Not for the People.
Mr. Harris?
Not for the defense, Your Honor.
All right, we've reset this for June 17th at 9 o'clock. Thank you for your appearance, Mr. Alvarez.
Thank you, sir. Have a good day.
You too.
Bye-bye.
You said one, I think you said one more.
Yes, I'm ready on Miss Fitzgerald over Zoom, and then I also have Miss Rogers for 10 a.m. She's here and she's ready, Your Honor.
All right, let's go on Miss Fitzgerald. All right, so we're on the record in docket 25-01117. That is the city of, the People's State of Michigan versus Nicole Fitzgerald. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the People.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Miss Fitzgerald, who is appearing via Zoom, Your Honor.
And ma'am, you are Nicole Fitzgerald, is that correct?
Yes, sir.
And you can hear me all right, Ms. Fitzgerald? All right, thank you. This is the time set for a pretrial in the matter. Mrs. L, how are we proceeding?
Your Honor, it's my understanding we're going to be asking for this to be set for a final pretrial.
Move on for final pretrial. Is that a fair statement, Mr. Harris?
Yes, Your Honor, we would be requesting that this case be set for a final pretrial.
All right, so that final pretrial will be live in person on the 6th floor of City Hall of Lansing, and we'll set it for the following date.
June 3rd at 8:30.
June 3rd at 8:30. So, Ms. Fitzgerald, you'll receive notice that will be sent to your last known address with the court, which is the North Martin Luther King address. Is that still a good address for you, ma'am?
Yes, sir.
Right, thank you. We'll set it for June 3rd at 8:30. That'll be live on the 6th floor of City Hall of Lansing as previously indicated. Anything else for the record in docket 25-01117, Mrs. L?
Not for the People.
Mr. Harris?
Not for defense, Your Honor.
All right, Ms. Fitzgerald, you're all set. Thank you for your appearance today.
Thank you. Have a great day.
You too. All right. And then there was the 10 o'clock.
Yes, Kyla Rogers. I do have an advice of rights and plea information form, Your Honor, if I may
All right.
approach.
Sure. Thank you, Mr. Harris.
Thank you.
Rogers. It's a part of the it's the Rogers and Rose, the last two at 10. The last one I have is post. Are they part of this afternoon's?
No, there should be this one.
All right, Ms. What's that? All right, give us a second. We gotta find your file, all right?
Yes, sir.
You gotta find the last two.
Should have just not out of order.
I just checked. I don't see Rogers or Rose in here.
Megan had pulled everything before she left, so I wasn't sure.
Yes. Were they with the afternoon? That would be my guess.
And I may have done that.
All right, Ms. Rogers. So we're on the record in docket 21-01694. That is people of the state of Michigan versus Kyla Rogers. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Izella, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Ms. Rogers, who is standing to my right, Your Honor.
And ma'am, you are Kyla Rogers, is that correct?
Yes, sir.
All right, thank you. This is the time set for a pretrial in the matter. Mrs. L, how are we proceeding?
Your Honor, it's my understanding there will be a plea in this matter based on the plea agreement that has been extended to defense through defense counsel. At this time, we are offering for Ms. Rogers to plead to an added count 2 of retail fraud in the 3rd degree under MCL 750.356D4, which is a 93-day misdemeanor and or $500 fine. There is no restitution in this case, and we would be agreeing to a killabrew of no upfront jail.
That is my understanding of the offer, Your Honor. I spoke with my client regarding the offer and the case. She indicated she wishes to accept the offer today, and we filled out an advice of rights and plea information form, which I have provided to court.
All right, and that's a retail fraud 3rd degree, right?
Correct, Your Honor, and just to clarify, upon successful plea, that would be dismissing the count 1 of the 2nd degree retail fraud.
All right, let me see. I gotta find this. All right. All right, Mr. Harris, may I inquire? I have the offers indicated. May I inquire of your client of their advice of rights and confirm that they've signed the bottom of their advice of rights?
Yes, Your Honor.
All right. Ms. Rogers, you've signed, these are 12 rights that you're willing to waive, and you've signed the bottom of this form, is that correct?
Yes.
All right. I'll just hit the 3 highlights of it. You understand you have the right to trial by a jury, to be presumed innocent until proven guilty, and you have the right to counsel in this matter. Do you understand that? All right. You also have the right to remain silent. Do you understand that? All right. If you're please accepted, you'll give the claim the plea result of any promises other than what's stated on the record or threats that it was not your choice to plead guilty. You'll also be giving up the right to appeal anything from trial. Since you won't be having a trial, you'll be pleading guilty to the retail fraud in the 3rd degree, the 93-day misdemeanor. Do you understand that? All right. There's an agreement between the attorneys, Mr. Harris, and the people of the state of Michigan that you not receive any jail time up front. If I was going to be different, if I was going to do something different from that, you'd have the opportunity to withdraw your plea. You understand that?
Yes, sir.
All right. Is it still your wish today to plead guilty to this offense?
Yes.
All right. Again, if you raise your right hand, do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? All right. I will bring your attention back to April 2nd, 2021 at the offense location of 6200 South Pennsylvania Avenue in the city of Lansing, commonly known as Meyer.
Yes.
At that time, was Meyer open to the general public for shopping?
Yes.
And did you, at that time, did you take property from the store valued under $200? All right. And at the time, it wasn't an accident, you did it on purpose. All right. Anything else for the record in concerning the factual basis of Mrs. Zell? Mr. Harris.
Not for the defense, Your Honor. Thank
All
you.
right, I find the factual basis to be knowing, voluntarily, and accurately made. We're going to we'll refer to probation. And really, it's so that they can, there's a killabrew, no upfront jail. When you're going to probation, that's really what they're going to be the heart of their questions.
Okay.
Is your criminal history, things of that nature. They'll have what they print off, They're going to ask you some questions about it. We'll see what options are available to us in sentencing. Of course, the Killebrew agreement is always an option, all right? All right, so we'll set the sentencing date for
July 15th at 1:30.
July 15th at 1:30. Probation is one floor down, all the way to your right, okay? They may see you today, they may schedule a meeting with you. I don't know what their schedule is, all right?
Yes, sir.
All right, so we've set the sentencing date for July 15th at 1:30. Anything else for the record in 21-01694? Mrs.
Not for the people.
Mr. Harris.
Not for the defense, Your Honor.
All right, we'll see you on that July 15th date, Mr. Hodgman.
Thank you. Have a blessed day.
You too.
Okay, thank you.
We're on the record in docket 25-00828. That is people of the state of Michigan versus Ernesto Silva. Will the parties please introduce themselves for the record? Mrs. Zell.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Silva. He is standing to my right, Your Honor.
And sir, you are Ernesto Silva, is that correct?
Yes, sir.
All right, thank you. This is time set for a pretrial in the matter. Ms. Zell, how are we proceeding?
Your Honor, it's my understanding we're going to be asking for this to be set for a final pretrial.
That is correct, Your Honor. A colleague of mine, Mr. Need, spoke with my client while I was handling some other cases. And then I confirmed with Mr. Silva here that the strategy for today would be setting it for a final pretrial. So we'd be requesting that final pretrial date.
All right, so we'll set it for final pretrial on
June 3rd.
June 3rd at 8:30. That'll be live today, just like we're here on the 6th floor of City Hall of Lansing. We'll set it for June 3rd at 8:30. You can get notice. Is Sean still there?
Permission to.
Yeah,
take the notice from-
we'll print out the notice and you can get it from your attorney, Mr. Harris. Is anything else for the record in 25-00828, Mrs. L?
Not for the people.
Mr. Harris.
Not for the defense, Your Honor.
All right, Mr. Silva, we'll see you on June 3rd at 8:30. Thank you for your.
Thank you so much.
I've got a few.
How are you, Mr. Lee?
I'm good, Your Honor. How are you?
Pretty good. What case did you want to go on?
How about Christopher Wilson?
Christopher Wilson. All right. And Mrs. L, you ready to go on, Mr. Wilson?
I am.
Thank you so much.
Thanks, George.
All right, Mr. Wilson, we're ready to call your case.
Yes, sir.
All right. All right, so we're on the record in docket 25-00429. That is the people of the state of Michigan versus Christopher Wilson. Will the parties please introduce themselves to the record? Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Christopher Wilson.
And sir, you are Christopher Wilson, is that correct?
I am.
And you can hear me all right, Mr. Wilson?
Yes, sir.
Thank you. This is the time set for for a pretrial in the matter. Ms. Izell, how are we proceeding?
Your Honor, it's my understanding that we're going to be leaving this or asking for this to be set for a final pretrial.
And is that a fair statement, Mr. Lee?
Yes, Your Honor.
All right, we'll set, are we using that same date? June 3rd at, so we'll set June 3rd at 8:30. That final pretrial will be live on the 6th floor of City Hall of Lansing. And Mr. Wilson, you'll get notification sent to the Hosmer Street address. Is that still a good address for you, sir?
It's 220 South Hosmer.
220 South Hosmer, correct?
Yes, sir.
That's still a good address for you.
That'll work.
Okay. So we've set it for June 3rd at 8:30. Mr. Wilson, I also got a note from the file to remind you that you're set for court on June 9th.
Yes, sir.
Okay, all right. So you're aware of that, sir?
Yes, sir.
All right. All right. Anything else for the record in 25-00429, Ms. Izell?
People.
Mr. Lee?
Nothing further. Thank you.
All right. We'll see you on June 3rd at 8:30. Thank you for your appearance today, Mr. Wilson.
Thank you, sir.
Mrs. Zeller, are you ready on that file? All right. So Mr. Mo, is it Mihok, Ding Mihok?
Yes, Your Honor.
All right. All right, so we're on the record in docket 25-01089. That is People of the State of Michigan versus Peter Ding Mihok. Will the parties please introduce themselves for the record? Mrs. Zeller.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the People.
Mr. Lee.
Thank you, Your Honor. Assistant Public Defender John Lee on behalf of Peter Ding Mihok.
And sir, you are Peter Ding Mihok, is that correct?
Yes, Your Honor.
And you can hear me all right, Mr. Mihok?
Yes, I can hear you very clear.
All right, thank you. This is the time set for a pretrial in the matter. Mrs. L, how are we proceeding?
Your Honor, it's my understanding that we're going to be asking for an adjournment of the pretrial to allow for some time for an assessment to be done by Mr. Mihok.
And so has the assessment been set yet, or is it still, we're still in the process?
We're still in the process, Your Honor. I'm going to be emailing him a list of providers
All right.
today. He's going to contact us.
All right, so that's a fair statement, Mr. Lee. I would think adjourn it 30 days out then,
Yes.
So Mr. Ding Mihok can get an assessment. Is that your understanding, Mr. Ding Mihok? You'll be getting assessment. We're going to set this 30 days out.
Yes, Your Honor.
All right. So we'll set it for
June 17th at 9.
June 17th at 9 o'clock for assessment purposes. All right, so we'll set for June 17th at 9 o'clock. Anything else for the record in 25-010809, Mrs. L?
Not for People.
Mr. Lee?
No, Your Honor, thank you.
All right, Mr. Ding Mihok, we'll see you for the second pretrial, which is available via Zoom on June 17th at 9 o'clock. All right, sir?
Okay, Your Honor.
You're all set. Thank you for your appearance today.
Thank you. Have a great day.
And then, Mr. Lee, did you have anyone else you ready?
You can.
All right. So we'll call your case, Mr. Harris. So we're on the record in docket 25-01314. That is People of the State of Michigan versus Demetrius Harris. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the People.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Demetrius Harris.
And sir, you are Demetrius Harris, is that correct?
Yes, Your Honor. I am Demetrius Harris.
All right, you can hear me all right, Mr. Harris?
Yes, I can.
All right, thank you. This is time set for a pretrial in this matter. Mrs. L, how are we proceeding?
Your Honor, it's my understanding we're going to ask for this to be set for a final
And
pretrial.
is that a fair statement, Mr. Lee?
Yes, it is, Your Honor.
So we'll set for final pretrial that same date, June 3rd at 8:30.
Yes.
Thank you.
All right, so we'll set it for final pretrial on June 3rd at 8:30. That'll be live on the 6th floor of the City Hall of Lansing. And Mr. Harris, you'll get notice sent to the West Michigan address. Is that still a good address for you, sir?
Yes, Your Honor.
All right. So we'll set it for June 3rd at 8:30. That'll be live in person on the 6th floor of City Hall. Anything else for the record in 2501314, Mrs. L?
Not for people.
Mr. Lee.
No, Your Honor, thank you.
All right, Mr. Harris, we'll see you on June 3rd at 8:30. Thank you for your appearance today.
Thank you.
All right, Mr. Etheridge, are you ready to go on Mr. Harris?
Your Honor, if possible, I'd like to meet with him in a breakout room for a few minutes. I
All right,
attempted
so-
to meet with him yesterday by Polycom, but he wasn't presented by the jail. So
All
I
right,
didn't
and
meet with
Mr.
him.
Is that Mr. Harris in post 2, visit 6?
Yes, it is, Your Honor.
All right, Mr. Harris, I'm going to place you in a breakout room with your attorney, Mr. Etheridge, and then we'll come put it on the record. So I'm gonna put you in room 2. And Mr. Etheridge, also, you'll get a prompt to go to room 2.
Thank you.
And then, Mr. Harris, did you need to meet with anybody or?
Yes, Your Honor, if I could meet with Ms. Spearman, please.
All right, so you'll go to room 4. And Ms. Spearman,
She's already there.
she's.
She's not sure.
So what I'll do, Mr. Harris, is I'll put you in room 3. Ms. Spearman, you'll also get a prompt to go to room 3.
Ms. Post?
Yes.
I'm gonna put you in a breakout room with your attorney, so you're gonna get a prompt to go to room 4.
Okay, sounds good.
I'll have, I'll email it to you.
All right, Mrs. L, what case did you want to call next?
If we could call the Centeno case, please.
Centeno.
then,
Enrique?
Yes, and then potentially get Mr. Etheridge case
All right.
as well.
2000, Mr. Centeno.
It's only on the felony. We just state misdemeanor.
A and D. All right. All right, so we're on the record in docket 2201240. And then 2402906. That is People of the State of Michigan versus Enrique Centeno. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Izal, Assistant Prosecutor for the People.
Mr. Lee.
Thank you, Your Honor. Assistant Public Defender John Lee on behalf of Enrique Centeno.
And sir, you are Enrique Eugene Centeno, is that correct?
Yes, sir.
All right, thank you. This is the time set for a competency examination. Mrs. L, how are we proceeding?
Your Honor, if I could defer to Mr. Lee.
Mr. Lee.
Thank you, Your Honor. Mr. Centeno was examined by the Center for Forensic Psychiatry, and it was determined that he was incompetent but restorable. This per a letter that we have dated May 7th, 2025 from the Center for Forensic Psychiatry.
It's the Morgan DeLeonard letter.
I'm sorry?
It's the Morgan DeLeonard was the writer of the letter. We're just making sure we have the same.
I have Vanderberg and
May 7th. Oh, Andrea.
yes.
Okay, yeah, we're working from the same.
Okay. We are waiting for the forensic psychiatry folks to get back with us to begin treatment and or whatever it is they intend to do to restore competency. In the meantime, Mr. Centeno is participating with and receiving care from CMH.
Oh, I know, I haven't.
Okay,
I mean,
so we're waiting for the Center for Forensic Psychiatry to get with us to establish care to get him restored, Your Honor.
All right. Is that your understanding, Mrs. Zell, that at this point in time, the defendant is incompetent to stand trial based on the report from the for the May 7th report from the order from the Center for Forensic Evaluation, and then there's a according to them, there's a substantial probability that the defendant, if provided a course of treatment, will attain competence to stand trial within a certain amount of time, but we don't have a plan yet.
That is my understanding, Your Honor.
All right, so with that understanding, we're probably going to need a control date. And then is the Center for Forensic Evaluation, are they going to be in contact, Mr. Lee, with your client in order to set up some type of plan, or that's all process driven right now?
My understanding is that yes, they will either be in contact with us or Mr. Centeno directly to set up that treatment. I
All right.
also, I'm sorry, go ahead.
Go ahead, Mr.
I was going to say, I also have an order of the finding of incompetence but restorable. Mr. Goodrich put this together if the court would like it.
I think I've got one right now on 2402906. Yeah, for competency with is your box 2 is checked.
That is correct.
All right. I think we have the same order. So based on what's indicated on the record and the reports, we will check box 2 that's checked. The defendant is incompetent to stand trial but restorable, as indicated by the Center for Forensic Evaluation. And I will sign on this date. We will set for a control date, I would say about 60 days out. Do you think that's a fair statement, Mr. Lee?
I think that's fair.
Yeah, I'm. So it'll be this is the finding of incompetence. So it'll be I think it's 18 months from today's date. Is that when the time starts running? I'm not sure. What's that?
I believe so.
18 or 8?
It changes. It changes depending on, it changes. This is a flee and elude fourth, which is a 2-year. I don't know where's it at on the list?
It's got to be, I think, 8 months, because I think
8
it's
months?
1/3 of
All
the
right.
time that they have, yeah.
Yeah, so I think you're right. I think you're absolutely right. And so we will set for 60 days out for review. That would be
July 26th at 8:30.
July 25th at 8:30. I've signed the order on file 24029006, and then we have the A and B file. I would think would follow it because we really can't do anything until competency is restored. So I'm going to indicate. So are the parties in agreement that this was set? Let's see what bond was on that.
That's just.
What is the bond on the A and B? Or was he released? I don't see a bond. 1,010%. And then he was released. Okay. Oh, it was posted? Okay, all right.
Well, somebody posted it for you.
All right. So that bond was posted. The pretrial conditions still are in effect. So there still is no contact with the victim in that case, which is a just to keep it. But that case has to be placed in abeyance, I would think. Tommy Thayer. So there's still a no contact order with Tommy Thayer, but the bond was posted on that because of the incompetence determination on the felony. We'll schedule that for the same time, I would think. Mrs. Ellis, do you have anything to add to that? That's what I would think, since we don't have a competency determination on the felony file, we'd set the misdemeanor for the same time.
I would agree with that.
All right. So incompetence determination on felony.
So does the determination of incompetency then apply to the misdemeanor case as well?
I'm just doing it out of a precaution. It doesn't, because there's not been a packet,
Right.
but I don't think that we can go forward on it if he's been determined incompetent.
Well, certainly not.
Yeah, I just don't. So we'll just set it with the other one, but he's been arraigned on it. So all the pretrial conditions and no contact order still stay in place.
Okay.
But I don't think we can go forward on it without additional review.
Gotcha.
So we'll set this with the felony file at the same date, July 25th at 8:30. And then, Mr. Lee, that's what I was looking into. What was bond set on the misdemeanor, and he posted it. So somebody posted on his behalf, because it was a below 10%. All right. I've signed the order for incompetence, but restorable. Anything else for the record on 22-01-024 for 24-029-06, Mrs. Ellis? Mr. Lee.
No, Your Honor. Thank you.
All right, you should be all set, Mr. Centeno. I would think that the evaluation center would reach out to you, okay?
Yeah.
All right.
Any call? Yes.
Call you with our call us.
And do you want to go on Mr. Harris?
Yes, if we could.
I think that's. That almost well.
Yes.
It would be the first time.
Yes.
All right, so Mr. Etheridge, we'll call your case with Mr. I gotta bring back Mr. Harris.
All right, Your Honor.
There he is. All right, so we're on the record in docket 24-02117. That is People of the State of Michigan versus Joseph Harris. Will the parties please introduce themselves for this record? Mrs. Zell.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the People.
Mr. Etheridge.
Good morning, Your Honor. Attorney Derek Esford, Office of Public Defender, on behalf of Mr. Harris. I'm appearing by video, and Mr. Harris is also appearing by video from the Ingham County Jail.
Thank you. And sir, you are Joseph Harris, is that correct?
Yes.
And you can hear me all right, Mr. Harris?
Yes, I'm Joseph Harris.
Perfect. This is the time set for a competency hearing. And Mr. Etheridge, for the record, you've had the opportunity to speak with Mr. Harris in a breakout room. Is that fair?
Yes, Your Honor, that is fair and correct.
All right. Mrs. Zell, on this competency hearing, how are we proceeding?
Your Honor, if I could please defer to Mr. Etheridge on this.
Mr. Etheridge.
Thank you, Your Honor. Your Honor, I had the opportunity to review the report with Mr. Harris. The report number or CFP number is 1021021, dated May 7th of 2025, signed and submitted by Laya Marshall, PhD, as well as a Michelle Hill, PhD. Their findings were that he was competent to go forward in his case. At this time, we're going to stipulate to those findings. Some of the major issues that I had with Mr. Harris dealt with criminal responsibility and some with competency. Once we address, if the case goes forward and we have to go forward and get the criminal responsibility completed in circuit court, we'll reevaluate our position on the competency. But at this time, we're stipulating to the report.
All right. And Mrs. Zell, do the people also stipulate to the report?
We do, Your Honor.
All right, I will sign the order that the defendant is competent to stand trial and the case shall continue to the next stage of the criminal process. I will sign that order on 24-02117. And then we will go to, did you want it set for another PCC and prelim?
I would leave that decision up to Mr. Etheridge.
Mr. Etheridge, did you want this set for another PCC? We know we've got to set it for another prelim, but did you want it also set for another PCC?
I don't know if that's necessary, Your Honor. I think we could just go to a preliminary, but I'd leave it to the court's discretion.
Okay. All right, perfect. We'll set for prelim. Is the 20th, May 20th. And Mrs. Zell, you'll probably need a couple weeks to get your witness, if you have witnesses.
Yes, at least 2 would be great.
Friday, June 6th at 1:30.
Friday, June 6th at 1:30. So we've set this live in person on the 6th floor City Hall of Lansing for Friday, June 6th at 1:30 for a preliminary examination. Anything else for the record in 24-02-117, Mrs. L?
Happen people.
Mr. Etheridge?
Your Honor, I would ask the court to entertain a bond motion if the court would.
You may make a bond motion at this time, Mr. Etheridge.
Thank you, Your Honor. Your Honor, Mr. Harris had posted bond before through a bondsman. He had missed his forensic interview. I don't think it was fully his fault that he missed it. There was issues with him getting the date and time and location. His bond ended up getting revoked because of missing that, and he's been in jail now for I think at least a month or so. And at the last hearing, I asked the court to reinstate his bond. At that time, I had talked to the bondsman, and the bondsman was willing to reinstate the bond with the same type of bond conditions, the same guarantor of the bond. I don't know if he still will do that or not since it's been a while, but we are asking that the court reinstate the bond.
So the initial bond was set at 100,000 cash surety. Is that correct?
That sounds right, Your Honor. They went through a bondsman. I think they paid the bondsman like 10,000 or something.
Right. And then he was remanded, and so you're indicating a reinstatement of bond.
Yes, what we're asking for, Your Honor. He would stay with his daughter. I think his daughter's going to make sure he gets to the court dates. He's advised me he will make sure he gets court date, not miss any more appointments. He does have concerns that he's going to try to go back to work, and if he continues to miss work, because he did work at GM, that he might lose his job. If the court is granting bond, I don't know what the bond conditions were, but I would ask the court to include bond conditions that he continue to seek and get treatment through community mental health, as well as continue and take all medications, including psychotropic medications. But I would ask the court to reinstate the bond, and whether the bondsman will he'll have to repost the 10,000, or the bondsman will re-guarantee it or not. I'm not sure at this time.
All right. Mrs. Zell, would you like to be heard on bond? So bond was originally posted at 100,000 cash surety because I arraigned him. And then we remanded him because he failed because we couldn't get a valuation. There is a no contact order. There is with the 4 victims in the case, and a GPS order also. And then he previously made bond. Mr. Etheridge doesn't know if he can remake it. We don't know what the bond person is willing to do, but the people's stance on it. These are fairly serious offenses.
They are, Your Honor. At this time, we would be against that bond reinstatement based on the failure to appears that did occur at the beginning of this case and the charges that are stated here. If Your Honor is willing to reinstate that bond, we would ask that it be reinstated at that full amount, or even a potentially higher amount. Thank you.
Thank you. So there's 11 counts here, and 1, 2, 3, 4, 5 of them are felony firearm. But I don't see now we've got the order to commit. I am going to reinstate a bond because I don't believe that he was remanded, so he is without bond. But I'm going to set bond at the new bond so this is sets new bond after, because I believe I have to. I think I have to set a bond after he's been found competent to stand trial, and we've remanded him for that purpose. But I'm going to set bond at 150,000 cash surety. So it'll be set at 150,000 cash surety on the new bond. He's not remanded anymore, but he's the similar bond conditions are to apply for the no contact orders in the GPS. There's also based on counsel's indication, There's a continue to follow all orders of community mental health, including any prescriptive orders for medication. And if he is to be released, he should go and get evaluated or at least seen by CMH. All right, anything else for the record in docket 2402-117, Mrs. L?
Not for the people.
Mr. Etheridge.
No, Your Honor, thank you.
All right, thank you. You're all set, Mr. Harris. We'll see you on June 6th at 1:30.
Thank you.
Thank you, Your Honor.
Thank you.
Yeah.
All right, so we're on the record. Ms. Spearman, you can unmute. We're calling your case. All right, ma'am. So we're on the record in docket 25-00048. That is people of the state of Michigan versus Jalissa Spearman. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Ms. Spearman, who is appearing via Zoom, Your Honor.
And ma'am, you are Jalissa Spearman, is that correct?
Yes.
And you can hear me all right, Ms. Spearman?
Yes, Your Honor.
Thank you. This is the time set for a pretrial in the matter. Ms. Ezel, how are we proceeding?
Your Honor, it's my understanding that we are going to be asking for this to be set for a final pretrial.
Is that a fair statement, Mr. Harris?
Yes, Your Honor. I've spoken with my client regarding the case in the offer sheet, and we are going to be requesting this to be set for a final pretrial.
All right. So we'll set with final pretrial live on the 6th floor of City Hall of Lansing. That's across from the Capitol. We'll set for final pretrial. We still use that June 3rd date?
Yep.
So June 3rd at 8:30. All right. All right, we will set it for June 3rd at 8:30. Ms. Spearman, you'll receive notification at your last known address with the court. And that is that Kaywood address still a good address for you, ma'am?
Yes.
All right. So June 3rd at 8:30, that'll be live on the 6th floor, City Hall of Lansing. Anything else for the record in 25-00048, Mrs. L?
Not for the people.
Mr. Harris?
Not from the defense, Your Honor. Thank you.
All right, Ms. Spearman, we'll see you on that date. Thank you for your appearance today.
Thank you.
All right. Ms. Downs?
Yes, Your Honor.
All right, so we're on the record in docket 22-03289. That is people of the state of Michigan versus Andrea Nicole Downs. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Ms. Downs, who is appearing via Zoom, Your Honor.
And ma'am, you are Andrea Downs, is that correct?
Yes, Your Honor.
And you can hear me all right, Ms. Downs?
I can.
Thank you. This is a time set for a pretrial in the matter. Mrs. L, how are we proceeding?
Your Honor, it's my understanding we're going to be asking for this to be set for a final pretrial.
And is that a fair statement, Mr. Harris?
Yes, Your Honor, we would be requesting this case be set for a final pretrial.
And we've been using that June 3rd date. All right, June 3rd at 8:30. So that final pretrial will be live in person on the 6th floor of City Hall of Lansing. And we've set it for June 3rd at 8:30. Ms. Downs, is that Cabot Road address still a good address for you, ma'am?
Yes.
All right. All right, you'll receive notice at the Cabot Road address. Anything else for the record in 2203289, Mrs. L?
Not for the people.
Mr. Harris?
Not from the defense, Your Honor.
All right, Ms. Downs, we'll see you on that June 3rd at 8:30 on the 6th floor of City Hall of Lansing. You should be all set, ma'am.
Thank you.
You're welcome. This is the Did you want to call? I don't know who's on the. Are you on the Sims case? I think she applied, but I don't know that she got an answer.
Your Honor, I looked into that. As far as I can tell, it seems like there was some indication that she may have been advised to call our office about filing an application. And there's a note in what little of a file we have.
Right.
Indicating that I think our office, someone from our office tried calling her twice, but wasn't able to ever get in touch with her or get that application.
All right. So you're not legally, you haven't filed an appearance on her behalf?
No, we have not.
All right. Mr. Lee, did you want to go anything else, or we can call that case, because that's a 9 o'clock, right?
Wait, is she here?
No.
Oh, I do have two that are ready.
All right, let's go on those then. Yeah. So, Mr. Lee, what would you like to go on?
I have Ashley Post and then Melissa Hunt.
Let's go on Ms. Hunt, and then we'll go on Ms. Post. All right, so we're on the record in docket 2403209. That is People of the State of Michigan versus Melissa Hunt. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Mr. Lee.
Thank you, Your Honor. Assistant Public Defender John Lee on behalf of Melissa Hunt.
And ma'am, you are Melissa Hunt, is that correct?
Yes.
Thank you. This is the time set for a pretrial in the matter. Mrs. L, how are we proceeding?
Your Honor, it's my understanding we're going to be asking for this to be set for a final pretrial.
And is that a fair statement, Mr. Lee?
Yes, it is, Your Honor.
So we'll leave on for final pretrial. I think we're going to have a new date. Maybe. All right. So it'll be that June 3rd date. What time? 8:30. All right. So we'll set for June 3rd at 8:30. That'll be live in person on the 6th floor of City Hall of Lansing. And is that Washtenaw address is still a good address for you, ma'am?
Yes.
All right. That's the last known address with the court. Anything else for the record in 2403209, Mrs. L?
Not for the people.
Mr. Lee.
No, Your Honor. Thank you.
All right. We'll see you on the June 3rd at 8:30 address live in person. Thank you for your service. And then we'll go on Ms. Post. And Ms. Post, you can unmute.
Okay.
All right, we're on the record in docket 2500820 and 2500821. That is People of the State of Michigan versus Ashley Post. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Ashley Post.
And ma'am, you are Ashley Post, is that correct?
That is correct.
And you can hear me all right, Ms. Post?
Yes.
All right, this is the time set for a pretrial in the matter. Mrs. L, how we proceeding?
Yes, if I could please defer to Mr. Lee.
Mr. Lee.
Thank you, Your Honor. Ms. Post has two files, one with the malicious destruction of property charge, the other with the dog at large charge. The offer from the prosecutor is to plead guilty to the dog at large charge. They will dismiss the malicious destruction of property, and my client will agree to pay the restitution that is due. That amount is $207.01.
And is that agreement a part of the dog at large case or the MDOP? Because we're dismissing the MDOP file.
I believe it would be the dog at large case.
Okay. I think that's the easiest way to do it for the clerks. but all right. So it is a plea to the dog at large. Dog at large is punishable by 93 days and/or what's the monetary amount?
I believe it's a $500 fine.
And then restitution again in the dog at large cases to be made too.
I'm sorry, the restitution in the dog at large case would be $207.01.
That goes to
Miss Tiffany Jones. And I can fill out a restitution sheet.
so that's your understanding, and then the MDOP would be dismissed per the negotiations.
That's correct, Your
That
Honor.
is correct.
All right, may I inquire, Mr. Lee, of your client of her misdemeanor rights on the dog at large?
Yes, Your Honor.
All right. Miss Post, you understand you have certain rights in this misdemeanor case. You've heard the plea offer. I will indicate it for the record. The plea offer is to plead to the dog at large, which is a misdemeanor punishable by 93 days and or $500. There's some restitution to go to Tiffany Jones for $207.01. With that, the MDOP will be dismissed. Is that your understanding of the plea agreement, ma'am?
Yes.
All right, you have certain rights, and I'll walk you through those rights. On the dog at large case, you have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond reasonable doubt that you are guilty, to have witnesses against you appear at trial, to questioning witnesses are brought against you. You are represented today by attorney John Lee, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people. Do you understand that, ma'am?
Yes.
You have the right to have the court ordering witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what we've stated on the record or threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial. Since you won't be having a trial on the dog at large case, you'll be pleading to that 93-day misdemeanor instead. Is it your still wish to waive your jury trial rights and plead guilty to the dog at large case?
Yes.
And if you raise your right hand, ma'am, do you solemnly?
Your Honor, if I could, one caveat, I'm sorry. She's actually going to plead no contest.
Okay.
She
Yeah, no
was not
contest, sorry.
when the incident occurred, so the facts in the police report are not disputed, but
Okay.
it'll be a no contest plea.
And is that a fair statement, Ms. Azell?
It is, Your Honor.
Okay, so it's a no contest plea, and the reason for the no contest plea would be
She was not there.
she wasn't there. All right, and
Is that what you emailed me?
Yeah.
There was no name. I didn't know where it
All
was.
right.
going.
all right, so for the no contest plea, ma'am, I'm in possession of an animal control report. This is what you'd like me to use, the factual basis. I'm looking for the number. So to make sure we're working from the same number, that is, it's a report indicated This occurred on March 14th, 2025, at 1317 Vermont Avenue. Is that, just so I'm,
That is the report I have.
All right.
I believe at the top, the incident number is 25-000912. I may have said too many or too little zeros.
598-00285. 1317 Vermont Avenue. Is that your understanding, Mr. Lee?
Yes, that is the same report. That
All
I
right.
have.
All right, let me review the report for the no contest plea. Okay, the indication is, and Ms. Post would know this because she was not at home. The indication from neighbors is that the dog has been out several times, and it looks like there's a hole in the fence that the dog's breaking through, according to the neighbors. Ms. Post did indicate that she wasn't aware of the facts of this case, but admitted that the dog had been aggressive in the past. All right, so I find that the factual basis that the dog was at large on the day in question, hence the ticket was written, and on March 14th, 2025, at the offense location of 1317 Vermont Avenue. According to the neighbors, the dog had been out on 2 previous occasions and then had made it through a fence or a problematic fence. It doesn't appear that the neighbors were home or Ms. Post was home at the time of the incident. But Ms. Post has taken responsibility for the actions of the dog, and the dog was referred to as, I don't know why I do this, but I do this anyway, is a cattle dog, Roman. I'm talking about Roman the cattle dog, 6 years. Anything towards the factual basis, Ms. Azell?
No, Your Honor.
Mr. Lee?
No, Your Honor, thank you.
I find the factual basis to be knowing, voluntarily, and accurately made. Do you have a restitution? All right. Restitution to Ms. Tiffany Jones is placed in the file. We can confirm the reputation, or we can go forward as part of this. How do you want to proceed, Ms. Azell?
I'm sorry, I'm not sure.
But with restitution, the neighbor should be talked to. There's restitution. I don't know if it's going to be contested. So I was going to refer to probation just for the investigation on that. That's the only thing that takes it out of the norm in a usual case, where I would just usually see if there's any objection to immediate sentencing.
I would not mind the referral to probation for those reasons. I'll defer to Mr. Lee on that.
Mr. Lee.
Yeah, Your Honor, I think that the restitution's been established and is on the record. We could do immediate sentencing.
Yeah, I'm kind of reluctant to it. It seems like a neighborhood dispute on some level. And so I hate to order restitution and then find out that we're back here anyway. So Ms. Post, we're going to refer you to probation. You'll have 48 hours to get to probation. So that'll be by Thursday. Or at least call them and find an appointment that will fit with everybody's schedule. And then you can indicate the restitution is for $207.01. They'll contact Ms. Jones but there seems to be some neighborhood dispute in the issue, and we want to make sure and clear that up. The sentencing date will be set for
July 15.
we'll set it for July 15th, sentencing date, July 15th at 1:30. So I'll see you again on July 15th at 1:30. They'll do a report, Ms. Post, and they'll ask you some questions, but we'll see what options are available to us at July 15th, on July 15th at 1:30. All right, ma'am?
Okay.
All right. Anything else for the record in docket 25-00821? Mrs. L.
Not for people.
Mr. Lee.
No, Your Honor.
And did I give you, in my absent-mindedness, I'm going to give you back the report so it doesn't make its way to the file. I have the pink sheet in the dog at large, and then I am going to sign the nollie at this time that you just signed on the case for the MDOP file, just for the record. So we'll see everybody on July 15th. Anything else, Mr. Lee?
Nothing further. Thank
We're
you.
all set, ma'am. Thank you for your appearance today.
Thank you.
Small.
So, Mr. Marcos?
Yes, Your Honor.
All right, so we're on the record in docket 24-03329. That is People of the State of Michigan versus Jeremiah Marcos. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Izzo, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Marcos, who is here from the Eden County Jail on a writ and standing to my right, Your Honor.
And sir, you are Jeremiah Marcos,
Yes.
is that correct? All right, thank you. This is the time set for a pretrial in the matter. Mrs. L, how are we proceeding?
Your Honor, at this time, we do expect a plea in this case. At this time, an offer has been extended to the defendant to defense counsel of a plea to an added count 2 of retail fraud 3rd degree under MCL 750.356D4, which is a 93-day misdemeanor and or $500 fine. There would also be an agreement to pay restitution in the amount of $459.98 to, I believe it is Meyer, and I will fill out a restitution sheet for that. Additionally, there is a Killebrew agreement to no upfront jail.
That is correct, Your Honor. I spoke with my client regarding the offer and the situation for reasons I can go into further on potential allocution. We are also going to be, I believe there may also have been an agreement with a potential request for time served. Given that my client has currently spent 88 days in the Eden County Jail, and I would be making a request for immediate sentencing, Your Honor.
All right. I don't have that. There was a small bond set on this one. I don't have that bond was ever made on this file.
I checked on the, at least on the court's website, and as far as I can see on the, at least public facing side of the court's website, there's an indication that the $50 cash surety bond was set, but no indication as to whether it was ever posted.
It's PR4. So he has at least credit for 4 days on this file. And then he's got all the time in Eden County that may or may not have credit for, but and yeah, do you have an objection to immediate sentencing on the file, Mrs. L?
No objection, Your Honor.
All right, with that understanding, Mr. Harris, may I inquire of your client of his advice of rights?
Yes, Your Honor.
All right, Mr. Marcus, you have the following rights in this retail fraud 3rd misdemeanor of 93 days and or $500. It is My understanding, it's going to be your wish to waive these rights, and I'll walk you through them. Okay, sir?
Yes.
You have the right to be tried by a jury, to be presumed innocent until proven guilty. You have the prosecutor prove beyond reasonable doubt that you are guilty. To have witnesses against you appear at trial. To question any witnesses are brought against you. You are represented today by Attorney James Harris, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir?
Yes, sir.
You have the right to have the court order any witnesses appearing in your defense to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give the claim the plea was a result of any promises that we haven't, that other than what we've stated on the record, or threats that it was not your choice to plead guilty. You'll also be giving up the right to appeal any issues from trial. Since you won't be having a trial, you'll be pleading guilty instead. Is it still your wish today to waive your jury trial rights and plead guilty to the 93-day misdemeanor retail fraud in the third degree?
Yes, sir.
You're gonna have to raise your right hand as best you can. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth on the penalty of perjury?
I do.
All right, sir, I'm gonna bring your attention back to if I can find it, to August 16th, 2024, at the offense location of, I believe it was Meyer, located at 6200 South Pennsylvania. Were you located, were you at Meyer on 6200 South Pennsylvania in the city of Lansing on August 16th, 2024?
Yes, sir.
And was Meyer open to the general public at that time?
Yes.
And did you take property of Meyer that was offered for sale less than $200?
Yes.
Okay, it could have been more than $200, but we know it's over a zero amount.
Yes.
Okay, and you did so. That wasn't an accident. You did so purposely. Okay. Anything towards a factual basis, Mrs. L?
No, Your Honor.
Mr. Harris?
Not from the defense, Your Honor.
Yeah, I find the factual basis to be knowing, voluntarily, and accurately made. We will go to immediate sentencing. I will follow the agreement of Killebrew up no upfront jail. So I'll sentence the jail to 4 days credit for 4 days previously served.
Your Honor, would the court like to hear me on allocution?
Absolutely.
And so on this case, when I spoke with Mr. Marcos, every time I've spoken with him, he has been apologetic. He's been remorseful. He realizes he has had some issues in his life that he is trying to rectify. He has had issues with substance use. He has issues with some mental health, which I understand is he's currently in the process of trying to address over with his Eaton County case. And there is a consideration for a mental health specialty court. Currently, he's trying to get himself back on the right track. He is willing to take responsibility and take the punishment the court sees fit to issue in this case. He is willing to pay restitution for the damage he has caused. Honestly, Your Honor, I realize the court has already addressed what it would be likely sentencing him to in terms of time. I would simply request the court sentence him to the time he's already served. And regarding fines and costs, given that he has the restitution that he's going to be paying once he gets out and once his case in Eaton County is resolved, I would ask that the court either order minimal fines and costs or potentially waive any fines and costs on this case, given that when he does get out, his finances and resources will likely be limited as he works to put his life back together. And I believe it would be in his best interest to put what limited resources he has towards any programming or necessary treatment over in Eaton County, as well as paying back that restitution, Your Honor.
What is the Eaton County case? I know that hasn't been resolved, but what's the current Eaton County case?
Same thing.
Same thing?
Yes, sir.
All right. Based on the allocution, Mrs. L, any allocution on this case?
Just, Your Honor, that while the Killebrew agreement was to no upfront jail, we wouldn't have any objection to the finding of time served if that's how you are inclined to rule today. Thank you.
Thank you. Mr. Marcos, is there anything you'd like to say to the court before the court passes the sentence? I am going to follow the Killebrew agreement. All right. So I'm going to sentence 4 days served previously. There'll be no additional jail. I'm going to waive fines and costs. I'm going to waive the state fee. And
I think the,
waive crime victims' rights fee. And we'll have the $459 restitution made to, and we'll refer that to collections. Yeah, we'll refer to collections. So when you get out on whatever the Eaton County's holding on, you'll have a collections case here, all right? And you can address that, but I'm going to refer that to collections. All right, anything else for the record? It's RTC. Anything else for the record in 24-03329, Mrs. L?
Not for the people.
Mr. Harris?
Not for the defense, Your Honor.
All right, Mr. Marcus, you're all set. Thank you for your.
thank you.
Brother, just really quick, the
Oh, let's get the
restitution.
restitution. This is. So let's see what files. I have Sims and Rose.
Yes, I would be ready to go on Rose if the court is ready to call that regarding Sims, as we discussed off the
Yeah.
record, we don't.
If you're ready to go on Rose, we can go on Rose. So and then we'll call Sims after that. So we're on the record in docket 25-00840. That is people of the state of Michigan versus Clayton Rose. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Clayton Rose, who unfortunately is not here in person or via Zoom, Your Honor. I did try and contact him regarding with a courtesy reminder of the court date on Friday of last week and again yesterday. Both times I did leave a voicemail clearly stating the date and time of the court date as well as where he needed to be. I unfortunately cannot explain his failure to appear today.
All right. This was initially set for 10 o'clock. It's now 11:30. Mr. Clayton is not in the Zoom courtroom or physical courtroom. Based on the representations of counsel, it appears Mr. Rose has failed to appear for the pretrial. We weren't sure, so it was reset as a courtesy reset on May 20th, today's date, from May 6th. Mrs. L, how did you want to proceed?
Your Honor, at this time, due to the fact that a courtesy reset has already been done when the defendant failed to appear at the last date, we would ask for a 48-hour hold on a bench warrant.
All right, I'm going to issue a bench warrant and bond forfeiture with a 48-hour hold on this, our 2 dog tickets, but Ms. Rose has simply not appeared and not been in contact. So that's all for the record in 25-00840. And I think that ends Mr. Harris and Mr. Lee till this afternoon.
I believe so.
All right, thank you for your assistance. And then we're on the record in 23-01214 and 23-01215. That is people of the state of Michigan versus Charlena Sims. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Right, this is the time set for a pretrial on both of these files. It was set for 9 o'clock. It is now 11:31. It would appear that Ms. Sims has failed to appear for the pretrial. Ms. Sims is not represented by the public defender in this matter, and they've been unable to contact Ms. Sims, or his contact has not been made. There was some questions concerning the application that was made, and she's been out of contact. So I'm going to indicate she's failed to appear on both of these files for the 9 o'clock pretrial. Ms. Zell, how did you want to proceed?
Your Honor, I do believe that this is a dog license case, and And so at this time, we would just ask for a courtesy reset.
So make a courtesy reset. I have her failed to appear last time on April 29th. So she failed to appear and we rescheduled this as a courtesy reset.
Well, in that case.
Yeah.
I may renew my ask and request a 48-hour hold on
Yeah,
bench warrant there.
I think at this point in time, we've kind of lost track. But I just saw that. I saw on April 29th, she failed to appear. We did, this was a set for courtesy reset. She was not bench warranted on that date. And then today's date. So we'll issue a bench warrant and bond forfeiture on these dog at large cases with a 48-hour hold.
Thank you, Your Honor.
All right. Anything else for the record in 23-01214 or 23-0215? Mrs. Al.
Not from people.
All right. Should be all set for the morning. I missed that also. So you you gave her a courtesy reset last time. So I think in the meantime she went and applied, but didn't finish any of the application or didn't respond to any of the calls.
Yeah.
And then that creates a problem. We can't get her here. I think the one civil has been taken off this afternoon. So we're just sentencing sentences this afternoon. And
Restitution hearing. They told me to make a report.
and a restitution hearing on Anderson. Deverone Anderson is.
Yeah, I gotta go see if the restitution stuff was actually sent to probation.
All right. You'll know whether we're going on it faster than I will. But that's set for 2:30. The rest, it looks like a couple sentences at 2:30, restitution hearing at 2:30, and then the rest of the stuff at 1:30.
Yes, no.
Judge, we would have gladly gave you our small claims hearing this morning.
No, you can have your small claims hearing.
Oh, my God. I'm like, somebody didn't warn me about this morning.
They're never about what they claim the small claims. It's always something else. Thank you, Mrs. L.
It was pretty bad. It was pretty bad.
I'm like, Kelly, where's David?
It was
We
bad.
always get it. We always get it on appeal,
Right.
as you know. And so if it comes to us, everybody's really good and mad.
Yeah.
Like everybody's
Yeah.
really good and mad. Like, you know, a decision's been made and it's not a justified decision. So when we get it, everybody's like, it's all personal. You know? Yep.
This one was the same way. The guy, him and the neighbor had a deal on the car.
Yep.
Where instead of just paying cash,
And Mr. Harris, who are we starting with?
I believe we would like to start with Aaron Miller.
Okay, Aaron Miller.
Yes, Your Honor, that's a sentencing.
So we're on the record in docket 24-03664. That is People of the State of Michigan versus Aaron Miller. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
And Mr. Harris.
Assistant Public Defender